Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about gift under Transfer of Property Act. Gift is generally regarded as a transfer of ownership of a property where the sender willingly brings into the effect such transfer without any compensation or consideration in monetary value. It may be in the form of movable or immovable property and the parties may be a two living person or the transfer may take only between after the death of the transferor. Now, what may be regarded as a gift? Section 122 of the Transfer of Property Act defines a gift as a transfer of an existing movable or immovable property. Such transfer must be made voluntarily and without any consideration. The transferor is known as the donor and the transferee is called donee. The gift must be accepted by the donee, and the section also defines a gift as a gratuitous transfer of ownership in some property that is already existing. This definition includes the transfer of both movable and immovable properties. Now let's see the parties under the gift of transfer. Donor. The donor must be a competent person, that is, he must have the capacity as well as the right to make that gift, and if the donor has the capacity to contract, then he is deemed to have the capacity to make a gift. This implies that at the time of making a gift, the donor must be of age of majority and must have a sound mind. Moreover, registered societies, firm and institution are referred to as juristic person and they are also competent to make a gift. Gift by minor or insane person is void under this. Now let's see donee. Donee do not need to be a competent authority to be into a contract. He may be a person in existence at the time of making a gift. A gift made to an insane person or a minor or even a child existing in a mother's womb is valid, subject to a lawful acceptance by the competent person on his or her behalf. A juristic person such as firm, institution and companies are deemed to be competent donee and the gift made by them is valid. Now let's see some of the essential elements under the gift. First is transfer of ownership. Second is existing property. Third is transfer without consideration. Fourth is voluntarily transfer with free consent. And fifth is acceptance of gift. Starting with the transfer of ownership. The transferor, that is the donor, must divest himself of absolute interest in the property and vest in the transferee, that is the donee. Transfer of absolute interest implies the transfer of all the rights and liabilities in respect of the property. To be able to such an effect, such a transfer, the donor must have the right to ownership of the said property. Nothing less than the ownership may be transferred by the way of gift. However, like other transfer, the gift may also be subjected to certain conditions. Now the second is existing property. The property which is the subject matter of a gift may be of any kind, movable or immovable, tangible or intangible, but it must be in existence at the time of making a gift and it must be transferable within the meaning of Section 5 of the Transfer of Property Act. Now, gift of any kind of future property is deemed void, and the gift of specific successions or mere chance of inheriting property or mere right to use is always void. Now, the third is transfer without consideration. A gift must be gratuitous. That means the ownership in the property must be transferred without any consideration. Even a negligible property or a very small sum of money given to any transfer in consideration for the transfer of a big property would make a transaction either a sale or an exchange. Consideration for the purpose of this section shall have the meaning same as given in the Section 2, Clause D of Indian Contract Act. The consideration is peculiarly in nature, that is the monetary terms. Mutual love and affection is not pecuniary conditions, and thus the property transferred is considered consideration of love and affection is a transfer without consideration and hence may be made a gift. A transfer of property made in consideration for the service rendered by the donee is a gift, but a property transferred in a consideration of donee, understanding the liability of the donor, is not gratuitous. Therefore, it is not a gift because liability involves pecuniary obligations. Then next is voluntarily transfer of with free consent. The donor must make a gift voluntarily, means in the exercise of his free will and his consent in his free consent. The free consent is when the donor has a complete freedom to make a gift without any force, fraud, coercion, or undue influence. The donor will, in executing the deed of the gift, must be free and independent. Voluntarily act of donor's part also means that he or she has executed the gift deed in full knowledge of the circumstances and nature of the transaction. The burden of proving that the gift was made voluntarily with the free consent of the donor lies on the donee. Now the next is, and the last essential is, acceptance of gift. The donee must need to accept the gift. Property cannot be given to a person even in the gift against his consent. The donee may refuse the gift as in case of non-beneficial property or onerous gift. The onerous gift are such where the burden or liability exceed the actual market value of the subject matter. Thus, acceptance of the gift is necessary, and such acceptance must be either expressed or implied. Implied acceptance may be inferred from the conduct of the donee and the surrounding circumstances. When the donee takes the possession of the property or of the title deed, there is acceptance of the gift. Where the property is on lease, the acceptance may be inferred upon the acceptance of the right of the collected rent. However, when the property is jointly enjoyed by the donor and the donee, mere possession cannot be treated as a evidence of acceptance. But when a gift is not onerous, even a minimal evidence is sufficient to prove that the gift has been accepted by the donee, and mere silence of the donee is indicative of the acceptance, provided it can be established and that the donee had knowledge of the gift being made in his favor. Now let's see what are the modes of making a gift. According to section 123 of the Transfer of Property Act, it deals with the formality necessary for the completion of a gift. The gift is enforceable by law only when these formalities are observed. This section lays down two modes for effecting a gift depending upon the nature and the property. For the gift of immovable property, registration is necessary, and in case of a property is movable, it may be transferred by the delivery of the possession. Then there is immovable property. In the case of immovable property, registration of the transfer is necessary, irrespective of the value of the property. The registration of a document including gift deed implies that the transaction is in writing and signed by and executed by the donor, along with attested by two competent persons and duly stamped before the registration formality are officially completed. Now for the movable property. In case of movable property, it may be completed by the delivery of possession. Registration in such cases is optional on the discretion of the party, and the gift of the movable property is effected by the delivery or in possession is valid, irrespective of the valuation of the property. The mode of delivering the property depends upon the nature of the property, and the only thing necessary for the transfer of title and possession is in favor of the donee. Anything which is in the party agreed to consider as delivery may be done to deliver the goods, which has the effect of putting the property in the possession of the transferee and may be considered as a delivery. Now the last topic of this video is actionable claim. Actionable claim are defined under section 3 of the Transfer of Property Act. It may be unsecured money, death, or right to claim movable, not in possession of the claimant. Actionable claims are beneficial interest in movable. Thus intangible properties. The transfer of actionable claims comes under the purview of section 130 of the Act, and the actionable claim may be transferred as a gift by an instrument in writing and signed by the transferor or his duly authorized agent. And the registration and delivery of the possession are not necessarily be required. That is all for today's video. Thank you for watching. Please like, share and subscribe.